This next case is the Foundation for Behavioral Resources versus Upjohn. It is a 15-minute mini oral argument on the application. Mr. Perry, that means you can attempt to reserve some of your time for rebuttal, but we ask you to try and keep track of that yourself. And if you are ready, you may proceed.
Thank you, Chief Justice McCormack. May it please the court, this is Michael Perry. I'm at Fraser, Trebilcock, and Lansing. Seated next to me is our newest associate attorney, Lauren Harrington. Lauren has helped me on this matter. She took and passed the July bar and was sworn in November. And we thought it'd be good for her to attend the argument with us today. The question before the court today, as the court well knows, based on its March 24 order, is whether a private figure plaintiff in a false light invasion of privacy action must prove malice under the New York Times versus Sullivan standard. As I suggested in one of my briefs filed in this action, I think the real question is not whether a private figure plaintiff should have to prove malice, but why should a private figure plaintiff have to prove malice when there is absolutely no First Amendment underpinnings or factors relevant to this particular action involving a private figure plaintiff, speech on a private business-related matter, not a matter of public interest, and a non-media defendant. When we look at those factors, I think that the conclusion that should be reached by the court, whether it grants leave or whether it makes it simply an order in lieu of granting leave in our favor, is that a private figure plaintiff, like the foundation, our client, the nonprofit corporation, does not have to prove malice. The parties have briefed this sort of endlessly, and I want to hit a few key points today. So, we know that the First Amendment requires a public figure plaintiff, even a involuntary public figure like the Hill family in Time Inc. versus Hill, in a false light action, in a matter involving a matter of public interest, must prove malice. That's what Time Inc. versus Hill said in 1967. And Time Inc. versus Hill applied the Supreme Court's own defamation analysis under the First Amendment back in 1967 to come up with that conclusion. However, and one of it relied upon New York Times versus Sullivan, among others, to reach that conclusion. However, 7 years later, in 1974, the US Supreme Court in Gertz 418 US 323 determined that a private figure plaintiff in a defamation case, another tort based on speech, did not have to prove malice, and that states were free to create their own standard of liability as long as it wasn't strict liability, as long as it was not no fault liability. There had to be an element of—
Mr. Perry, let me interrupt you because the time is short and I want to make sure you have a chance to answer questions. And if there are none, we'll get back to you. Okay. And I'll start with Justice Bernstein.
Good morning, counsel, and congratulations to your new associate. Welcome to the practice of law. Welcome to the bar. You know, I just have kind of a simple question, and I think you're pretty much going to the essence of it. It just seems to me, and you know, perhaps you can correct me if I'm wrong, but it just has always appeared to me that there was kind of like the underpinnings of understanding conceptually that malice was somewhat kind of used for public figures. And I'm trying to see, as you were just putting forth in your arguments, if anyone in this matter is a public. It just seems like maybe I'm missing something, but I've just always think that this is the kind of thing that goes back to not just what you learn in law school, but it's almost kind of what you would learn in a communications class in college as to, you know, what is required for private versus public officials.
Yes, I agree with you, Justice Bernstein. You've hit the nail on the head. And this court has recognized that private figure, public figure dichotomy in its earlier jurisprudence in the area of defamation. And there's really no reason why the court should not recognize that dichotomy in another speech-based tort, false light invasion of privacy. So I agree with you.
Thank you, Counsel.
Justice Clement.
I'll follow up on that line of question then. Does it matter that your client is a nonprofit organization and not an individual?
Well, Justice Clement, that takes me to another point I was going to make today. First, as the court knows from my brief on this question, we would ask that the court disregard the amicus argument on that point. The parties did not present this issue to the lower court. We have established in this state the parties' presentation principle. We have recognized the adversarial system in the Michigan gun owners case. Justice McCormack, in a footnote, talked about perhaps we should just do away with the adversarial system if we're going to make decisions based on arguments presented by the amicus or created by the court itself, rather than looking at what the parties themselves presented. My colleagues, Edgar and Lukow, vigorously defended this lawsuit, brought a summary disposition motion challenging every part of my claim, essentially. They apparently chose not to present that issue, so it hasn't been addressed so far. So we would ask the court to disregard what the amicus said about that. But setting that aside, I recognize that the majority rule across the country, perhaps without a lot of analysis, is that corporations do not have the same kind of right to privacy as individuals have. I recognize that many courts have said that. Other courts, though, have found that a corporation, both for-profit and nonprofit, has a right to privacy in certain circumstances. And I would suggest that this is one of those circumstances where our client presented a lot of data and information about its business practices to another private party, and that private party chose to release false information based on that material that my client, another private party, had presented to it. And then to top it all off, the recipient of that information, the defendants, who were also the speakers here, then at the same time, they released this false information and paint our client in a false light, award the contract at issue to itself. So it benefits essentially from its own false statement by placing our client in a false statement or a false position. So we're looking at the tort of false light invasion of privacy. I think the court could conclude that a party like the foundation, in this circumstance, when we're dealing with private business information and private parties, and a defendant private party puts the plaintiff, another private party, in a false position, that the plaintiff, my client, would have a right to privacy in that setting. Certainly a corporation can be put in a false light and in a false position the same way an individual can. There's no reason to distinguish between them. And then the last point I wanted to make on that, Justice Clement, is corporations, like all organizations, are collections of people. Human beings make up the corporation. The court is an organization composed of people. My law firm is an organization composed of people. Garen Lukow is an organization composed of people. So the fact that a corporation is involved, we still have an impact upon the people in that organization. I'm not suggesting that the individuals would have a cause of action. I know that the cause of action here was brought by the corporation. But I think in this unique circumstance, and in light of other cases that have recognized the right to privacy for certain corporations in certain settings, this is the kind of case that fits within one of those settings. I know that the amicus, for example, made the point that some of the organizations or corporations that we had referred to in one of our briefs were membership organizations, like an association or a political organization. Well, a limited liability company is composed of members. So is that going to be the touchstone that there have to be members? What's the difference between a member and a stockholder, between a member and an employee, when it comes to the placing of the organization in a false light in the eyes of the public? So I think there's no difference, and I would urge the court, if it's going to consider that issue, to find that our client organization has a right to privacy in this circumstance.
Justice Cavanagh.
No questions for me.
Justice Welch.
Thank you. Counsel, I have to admit, this is it's a bit of a strange tort to me. We are talking about one's reputation, which is, that's how you look to the public, obviously. But obviously, the tort is rooted in this privacy interest. It does seem at odds with each other, and I struggle to wonder why, we don't just use defamation for these cases. I'm wondering if you could help enlighten me a little bit.
Yes, Your Honor. I think the law of torts recognizes false light invasion of privacy as an alternative to defamation. They both arise, of course, out of making a statement that is false. So in some respects, they're very similar. But in a false light claim, the plaintiff does not have to prove that the statement was defamatory, as the courts have defined what a defamatory statement is, that would deter third parties from associating, or likely to deter third parties from associating with the plaintiff. That's not an element of a false light claim. So it's an alternative that the law recognizes, that a false statement about a party could give rise to an alternative cause of action. I think the Court of Appeals in Morgan-Roth, 160 or 161 Mishap by memory, cited in our original application, makes that point, that the law is well established in that regard in terms of recognizing an alternative cause of action for a plaintiff essentially damaged by another party's statement.
So I'm still trying to figure out what privacy right is being protected here.
Well, the privacy right here would be the statement at issue is the defendant's statement that the foundation failed to meet the minimum threshold, the minimum scoring, because this was part of this evaluation on this contract matter, was based on a so-called objective analysis, that it was scored, and the applicants had to meet the 75% threshold. So based on the confidential business information that our client provided to Upjohn reported that we failed to meet that standard. So they used the private business information as a basis to make their false statement, because clearly the foundation had met the standard, and there's no dispute between the parties that there was a mistake made by Upjohn and killed some of its scorekeepers there when they did it.
So if we remove the malice requirement, isn't under your argument, every internal corporate discussion, making decisions about contracts, wouldn't that open the floodgate of litigation for lots of decisions that companies make every day?
No, Your Honor, because in this case, the tort depends upon the publication of the information, the broadcast of that information to a large group of people. In the Welch case, for example, the Michigan Court of Appeals found that a publication to, I think, 50 physicians or other interested parties in the matter at issue met that criteria of a large group, but you have to have a large group of people to which the information is published. Here we have it broadcast across a website or on a website to all entities interested in these Michigan Works employment training and job placement programs. And there's never been an issue in our case that there was a broadcast to a sufficient number of people to meet that element. So in answer to your question, a unique aspect of this tort is there has to be a broadcast of the information, a publication to a large group of people. The law doesn't define what that large group is, but so I think that that's a distinction that would mitigate against the idea that there would be a massive number of new lawsuits brought in this regard. That the publication factor is not, well, strike that. I think I've answered your question.
Thank you. I appreciate it.
Thank you.
Mr. Perry, I agree with you that the First Amendment would not be a bar to changing the requirements for proving false light to not including malice when a private individual is the defendant. But my understanding is that the overlap between the two torts, defamation and correct me if I'm wrong, and false light is not only that the information need not be false for false light, it's that while defamation compensates you for harm to reputation, false light compensates you for damage to a person's feelings or emotional well-being, which to me roots its doctrinal history in sort of a personal tort. And if that's right, and malice has always been required, why is following the defamation path, which has these, in my view, two different elements, one that should appeal to us? I mean, it's a tort that's always been rooted in the damage to feelings or emotional well-being, and always has had in all the jurisdictions I can find a malice element. So I'm not sure why defamation should be tempting to us that much.
Well, Your Honor, Prosser, among others, recognized, at least in 1960, and maybe others since then, that an aspect of a false light claim does involve, since it pertains to holding one out in the eyes of the public in a false light, it does involve, in some respects, damage to one's reputation. I understand that most of the cases talk about personal feelings, that people are embarrassed or upset that information has been disclosed and they've been placed in a false light, and there's sort of an emotional distress element to that. And I appreciate the fact that corporations don't have emotions. They're legal entities artificially created so organizations of people can do business. But there is a reputational aspect to a false light invasion of privacy claim. And I think that's why the defamation related analysis applies here.
Okay.
Because both torts address or allow a plaintiff to seek redress for damage to the plaintiff's reputation.
Okay, Justice Zahra.
Harry, it seems to me you've got a very steep uphill battle here. The Court of Appeals has recognized that there's a long line of published cases applying malice as an element in a false light claim, including when the plaintiff is a private figure. This court has recognized in a peremptory reversal order that in a false light claim, the plaintiff must, quote, prove by a preponderance of the evidence that the defendant must have known or acted in reckless disregard of the falsity of the information and the false light in which the plaintiff would be perceived, end quote. That's the DAD order from 2010.
Yes.
The law I've just described is consistent with the restatement of tort second, which would also require a showing of malice. In response to all this, you tell us in your brief that requiring malice is against Michigan's public policy for protecting a private figure plaintiff's reputation. But this court in Terrian v. Zwitt considered what must be shown to establish Michigan public policy. And there the court said, quote, in defining public policy, it is clear to us that this term must be more than a different nomenclature for describing the personal preferences of individual judges, end quote. The court went on to say, quote, public policy is to be ascertained by reference to the laws and legal precedents and not from general consideration of supposed public interests, end quote. So I guess my question to you in light of all of this, what in our statutory laws and what in our legal precedent supports your claim that requiring a showing of malice for a false light claim is against Michigan public policy?
Well, Justice Zahra, we have, if we want to look at statutes, and this is on the defamation statute, a private figure, the legislature has determined that a private figure does not have to prove malice in a defamation claim. That's in Compiled Law 600.2911, subpart 6. This court made that decision before the legislature did, so we have both the legislature and the court making that decision in the defamation context. So I would think those are two indicia of the state of Michigan's public policy insofar as defamation is concerned. Insofar as false light invasion of privacy is concerned, we cite at least one case that dates to the 1800s where Michigan, in fact, I think Prosser noted that Michigan is one of the leading jurisdictions in the recognition of the right to privacy. I don't recall the site off the top of my head, but it's in our brief. And so Michigan historically has had a commitment to protect the privacy of parties that come to its courts. I would note too, as the Court of Appeals frankly admitted or acknowledged, that although the Court of Appeals has had 35 or 40 years of published opinions involving false light claims where they blindly recite the elements, no Court of Appeals opinion other than ours has analyzed the question. And the Court of Appeals, in a footnote, which I have in front of me on my desk here, suggests that the bench and bar would benefit from the grant of leave so that this court could address the question. So adding all those up, I think weighs strongly in favor of granting leave and addressing the question before the court.
Thank you.
Thank you.
Justice Viviano.
No questions. Thank you.
Mr. Perry, we used up all your time and then some, so thank you very much. And I will turn to Mr. Saylor.
Thank you. So,
Thank you, Your Honor, and good morning, and may it please the court. Daniel Saylor for the defendant. Your Honor, the question here in the proceedings at this stage is whether or not the court is interested in granting leave and deciding the question presented. So the court is interested in, has expressed some interest in whether to change an element of the common law of Michigan, whether to reduce the standard in a private plaintiff's false light invasion of privacy claim from a knowledge reckless disregard standard of falsity to a negligent standard. And so I believe the first question is whether this case is a good one, an appropriate one in which to address and decide that question. And I would submit, Your Honors, that it is not, because in the context of this case, intriguing though the legal issue may be, it is purely academic. The court's decision in this case will have no impact whatsoever on the outcome of this litigation. And it's my understanding, this goes to the advocacy process, the adversarial process. It's my understanding that in any case this court takes, the court deserves and expects what I would call highly incentivized advocacy from both parties to ensure that the important legal issue to be decided is fully and aggressively vetted. Not to say that the briefs have not been, a lot of effort has not gone into them, it has. But here where the circumstances of the case effectively reduce the issue to an academic question, you do not have that assurance. And the issue has to matter in the case. And so I want to explain why in this case, this issue is purely an academic question that will have no impact on the outcome. First, it's clear that what plaintiff is seeking is compensation for damage to its reputation. It has made that abundantly clear in its briefs. At page 23 of their application, they conclude the application with a quote about the reputational interests that are protected in defamation cases. And it says, quote, FBR's false light invasion of privacy action seeks redress for damage to its reputation. They already have a claim going to the jury on seeking compensation for damage to its reputation based on these statements, which they acknowledge are the identical statements being proffered in the false light claim. They already have a claim seeking that compensation for that damage on a negligent standard. So the fact, if this court were to grant leave and change the law to reduce the standard in a false light private plaintiff case down to negligence, it would simply go back to the trial court and at best go to the jury on the identical claim, in this case, redundant of the other case. Now, there were questions about, are there differences? And there are slight differences. But in the context of this case, there's absolutely no difference. It is based on a allegedly defamatory false statement. And while in a false light claim, the law does not necessarily require that the statement be defamatory, it's hard to say exactly what the difference is because it does require that the false light, the false statement, places the other is placed would be highly offensive to a reasonable person. So it sounds like defamatory to me.
Oops.
I'm sorry.
Let me interrupt you and see what
Sure.
questions folks have. My sound seems weird. Okay.
I hear you.
Good. Justice Bernstein,
I have no questions. Thank you.
Justice Clement,
No questions, thank you.
Justice Cavanagh,
Good morning, Mr. Saylor, but I have no questions today.
Justice Welch.
I guess, Mr. Saylor, I'll bite a little bit on this notion of defamation and libel laws. It appears to me they cover a lot of the concerns that have been raised, and I'm just wondering what your thoughts are. I know some other states have actually decided that these false light claims should no longer survive, and I was just wondering what your viewpoint is on that.
Well, I would say that there is a conceptual difference in the roots of each claim. And it's been established in the briefs, and frankly, the amicus brief does a good job on this. I believe ours does as well. But a false light claim is focused at compensating injured feelings that result from being cast in this false light to some large group of people or publication. Whereas defamation seeks to compensate damage to reputation, which, as the amicus said, is by definition not private. It's reputation. Interestingly though, in a false light claim, the plaintiff, a person who has injured feelings due to the false light, can also recover for the damage to their reputation that results from that as well. And likewise, incidental to a defamation claim, the person, if appropriate, if it's a private person, can also recover for their injured feelings. So there's clearly overlap. It's just a different focus on the root of the claim. And that goes to another reason why this case, however this court might decide it, will have absolutely no impact on the outcome of this litigation. Because when it goes back, if it were to be reversed and a negligent standard applies to this false light claim. It would go back to the trial court, and contrary to what plaintiff is suggesting, we absolutely still have the defense that a corporation does not have a false light claim. That was never waived. We filed a motion for summary on grounds that they can't meet their one of their elements, and it was granted. The court ruled, specifically MCR 2.116E3, directly allows parties to bring a second summary disposition motion on another defense. And it has not been waived. It has not been addressed yet. That issue will be presented. And because the root of the tort is injured feelings, there is no cause of action on behalf of a corporation. The restatement is very clear on that. And to my knowledge, there's been no criticism or doubt about that element. So for both of those reasons, it's a redundant claim that they do not need in order to be fully compensated for whatever they can prove by way of damage. And it is frankly unlikely that this theory, even if it goes back down, would ever go to a jury anyway. So my point is, if this court is interested in eventually examining the common law and changing the common law in Michigan to change the standard of proof in this type of a claim, it should really find a case where it will make a difference in the outcome of the litigation so that the proper advocacy and vetting of the issue is presented, and you know that you will be having all the information you need to make an important decision like that.
Thank you.
It should be denied, and it would be our position, Your Honors.
Justice Zahra.
No questions, thank you.
Justice Viviano.
No questions, thank you.
Mr. Saylor, you have another 6 minutes. You can use as much of it as you like.
I think I've made my point. I will just touch on one point, sort of in response to the suggestion that this case does not involve any First Amendment considerations. I would dispute that. I believe, and I think that the concluding brief by the amicus points this out, that even a private person's cause of action, whether it's for defamation or false light, raises the constitutional right of free speech. And when the court establishes a common law rule that in some way restricts or potentially penalizes or renders someone liable for their speech, that right is invoked. It doesn't mean that it can't be overcome, or that in the right case, a negligent standard may be sufficient protection. But it certainly, for instance, would stand in the way of a strict liability tort in that regard. And so I would just push back on the notion that this does not involve First Amendment considerations. And there are other points to be made about the merits of the differences and why a defamation case may be appropriate to reduce, and it has been reduced to a negligent standard. But in this case, for a false light claim with a private plaintiff, it should not be. The briefs have shown that Michigan already accommodates that difference between a public plaintiff and a public figure plaintiff and a private figure plaintiff by changing the burden of proof from clear and convincing evidence down to an ordinary preponderance of the evidence for a private plaintiff. So you would have to analyze all that and decide which approach is better, changing the negligence versus the actual malice standard, and then also changing that burden of proof or leaving both. As I say, this is not the right vehicle to make those considerations, because it is not in any way outcome determinative or even having any impact on the outcome of this litigation. So I think that for those reasons, I would just urge the court to deny leave to appeal.
Thank you, Mr. Saylor. Mr. Perry, we used up all your rebuttal time, but thank you very much, both of you, for your presentations. Congratulations, Ms. Harrington. Welcome to the practice of law. The case will be submitted.
Thank you.